Hello, welcome to the channel. It's me, Chris Brooks. I hope everyone's well today. So today I would like to dive into a subject that touches all of us. Bills and demands for payment. And a very specific piece of law that might just change how you look at them. You know, we've all received what appears to be bills through the letterbox. Your mobile phone, council tax, electricity, water, credit card repayments. But here's the thing that many people aren't aware of. Many of these so-called bills don't actually meet the legal definition of a bill of exchange. Let me explain. In the UK, the law that governs this area is the Bills of Exchange Act 1882. In Australia, it's the Bills of Exchange Act 1909, which is almost identical in its wording. The key section is section 3.1 of the UK Act, which reads, "A bill of exchange is an unconditional order in writing, addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to the bearer." Crikey, I won't tell you how many attempts that took. Now let's break this down into plain English. To be a valid bill of exchange, a document must be an unconditional order to pay. Not a request, not a suggestion, but a command. 2. It must be in writing, not verbal or implied. 3. Must be addressed from one person to another person, meaning that the issuer is telling a specific person or party to pay. 4. Must be signed by the person giving it. This is a critical part. 5. Require a payment on demand or at a fixed or determinable future time. 6. It has to be for a specific amount of money. 7. Be payable to a specific person, their order or bearer. Even if one of those conditions is missing, and only one of those conditions is missing, it is not a valid bill of exchange under the Act. So here's the big question. When you receive a utility bill, is it signed by the individual issuing the demand? Usually, no, it's not. There's often a company logo, a barcode, and some printed text, but very, very rarely, if ever, is there a wet ink signature or even a digital signature from the person issuing the demand. So no actual authorization from anybody. And that's the issue. Under the Act, a valid bill of exchange must be signed by the person issuing the demand. The Act isn't referring to an impersonal system printout. It's talking about a personal and accountable act. One human giving another human a written signed order. And this is where it gets interesting. If a company sends you an unsigned demand for money, then legally it may not even qualify as a bill of exchange. It may only be a statement of account, or at most a request for payment, but not a legally enforceable instrument under this Act. Now that doesn't necessarily mean that you don't owe the money. There are other laws such as contract law, consumer credit regulations, but it does mean that you should question the legal standing of the document itself, especially if somebody tries to treat it as a negotiable instrument. You see, a bill of exchange can be used like a cheque, something that can be endorsed, transferred, or enforced through legal channels. If it's not valid under that Act, then it lacks those powers. It's not negotiable in the same way. Now this is particularly relevant when dealing with debt collectors or institutions who claim that you are in default based on a so-called bill. And so if it hasn't been correctly issued and signed under the terms of the Bills of Exchange Act, you have the right to question its legitimacy. So what can you do? Ask for a copy of the original signed bill. Ask who the issuer is and whether they have personally signed and issued the bill. If the document doesn't meet the legal requirements, consider stating that it is merely a statement of account, not a valid bill of exchange. This isn't about avoiding legitimate obligations. It's about understanding your legal rights, especially in a world where automation and faceless systems produced hundreds and millions of documents that look official, but may not have the legal substance behind them. So in conclusion, not every document demanding money is a bill of exchange, even if it looks like one. The law is quite clear on what qualifies, and if it's unsigned by the issuer, it doesn't qualify. Thanks for watching, and I hope this has helped you think a little bit more critically the next time a so-called bills of exchange comes through your door. Look after yourselves. Enjoy your day, and I'll speak to you all again soon. Bye for now.